Hello and welcome to Tobacco Control Policy 101, a webinar presented by Public Health Law and Policy. This is Ian McLaughlin. I'm a staff attorney here at PHLP, and we're going to spend the next hour or so talking about understanding the legislative process. And by that, I really mean today the local legislative process. I think understandably a lot of folks use the term legislative process and really they mean the state or even federal lawmaking process, and of course those are very important. But today's webinar is going to be focused on what happens in city councils and boards of supervisors when we're talking about the local legislative process, because a lot of the work that we do in tobacco control in California is really focused initially at the local level. So we're going to focus there for today's webinar as well. I can't help but mention that every time that I talk to somebody about the lawmaking process in general, I'm reminded of the famous quote that laws and sausages are a lot alike in that you really don't want to know how either one is made. And as true as that may be for sausages, I think exactly the opposite is true for lawmaking. Those of us who think that policy is important to improve public health, whether you're talking about tobacco control, nutrition, physical activity, chronic disease more generally, whatever policy you're using, and whatever role you have in the policy-making process, having a better understanding of the entire process will really help you in your work. So as much as Otto von Bismarck might have found it distasteful, it is really important to know the process for making laws, I think. For those of you who have not worked with our organization before, Public Health Law and Policy is located in Oakland, California, and we're a team of attorneys, urban planners, policy professionals, and public health professionals that really partner with state and local leaders to create policy solutions to improve public health. And we really try and focus our work on the underserved. We research legal and policy issues, develop model policy language, and really importantly, we help work with local leaders to implement those policies in their communities. As I said, I'm Ian McLaughlin, and joining me today for the webinar is my colleague Matthew Moore. In addition, we're going to have a couple of guests later in the webinar. We're going to have Christine Glaze from the Search to Involve Filipino Americans based in Los Angeles County, and Denise Dennis with Contra Costa Health Services. Both Christine and Denise are experts in the field of tobacco control and have done a vast amount of work creating local policy solutions, so they're going to share some of their experiences with us today. Before we begin, I'd like to give you an overview about what we're going to talk about during today's webinar, and we're going to try and be as comprehensive as possible, focusing on some of the considerations before you start doing your policy work, and then what actually happens during the legislative process, and what points of intervention can you identify for you and your colleagues in the field. So here's an overview of the 6 substantive areas that we're going to cover for today's webinar. We're going to talk about the difference between a policy, which we use to mean a voluntary or organizational policy, versus a law, legal authority for local laws, the anatomy of an ordinance, the actual process that occurs at the City Council or Board of Supervisors, some of the key players in the process, and then finally how to use TALC's materials and services in your work. TALC is the acronym for the Technical Assistance Legal Center, and you heard me identify us as Public Health Law and Policy earlier. TALC is one of the projects of Public Health Law and Policy. So that's a roadmap for today's webinar. We're going to try and follow that, and for the first 2 bullet points in the overview in our agenda, I'm going to turn it over to my colleague Matthew.
Thanks, Ian. For the first section of our presentation, we're really going to focus on the distinction between a policy versus an ordinance, which is a type of law. So really the distinction, a law is a type of policy, and so we want to sort of thread that needle and help understand the distinction. So to begin with, we're going to talk about what we're calling organizational policies. And in the field, these are often referred to as voluntary policies. And the reason for that is because they are rules that are enacted by an employer or a property owner or an event organizer, someone with control over a particular area or property that applies specifically to that area or property. So for example, a business owner may establish a policy regarding smoking, where smoking is allowed in some areas but not in others. In addition, it could be any number of different types of policies that are voluntarily enacted. For example, an employer or a property owner could implement a no rollerblading policy. A property owner that controls a particular body of water could have a no boat policy. And in addition, not only do they potentially require or prohibit certain activities, they could also require, a policy could require something of the actual property owner or manager. And a good example of this would be an accessibility policy for disabled individuals. So those are voluntary policies. Now, what's the distinction then between a local ordinance? Well, an ordinance is a law that's passed by elected officials in a city or a county that restricts certain behaviors or requires certain behaviors with penalties provided for noncompliance. And just as with a voluntary policy or an organizational policy, local ordinances apply specifically within the boundaries of the jurisdiction where they're passed. So if it's a city, then it applies specifically within the boundaries, within the borders of that city. So in terms of tobacco control, what are the pros and cons of the approach of using voluntary policies created by business owners or property owners rather than the ordinance approach? Well, we're going to weigh the pros and cons of each. So to begin, let's talk about organizational policies. What are the advantages of organizational policies or voluntary policies? First is that they can apply specifically to certain people or to a specific location. This is what we often refer to in the legal field as being narrowly tailored. Part of the advantage of this is that by doing so, they build support among the community, essentially by setting a good example. What are the cons, though? The downside is that voluntary policies are essentially a piecemeal approach. They are enacted facility by facility, and they're not legally binding. So any new employer or property owner or organization is free to completely discontinue the policy pretty much on a whim. And so in a sense, they're impermanent. So moving on to local ordinances, or to ordinances, the advantages there are as follows. Widespread application. Widespread application basically means they apply to everyone equally within that jurisdiction. It's a uniform standard that applies to everyone. They offer a long-term policy solution. By passing an ordinance, you're doing something that's legally binding, that it's actually very difficult to repeal or overturn an ordinance once it's been passed. And then also, social norm change is something that we refer to that refers to changing the culture around a specific issue. So in tobacco control, when you have an ordinance that prohibits smoking, for example, in restaurant patios, because they apply equally to all restaurants within the city, it becomes the new normal, and over time, smoking in those places becomes something that people don't even think about. They just wouldn't do it anymore. So what are some of the downsides of local ordinances? Well, the biggest is that they can generate very strong opposition. This is in part because they are widely applicable to everyone in the specific jurisdiction, and so they motivate stakeholder groups to show up in force, either in support of or against. And so the result of that is that in order to get an ordinance passed, it takes a lot more work. There has to be political will developed in order to actually accomplish it. So back to our roadmap, the next point that we're going to cover is legal authority for tobacco control laws. And this is really the authority of local government to create tobacco control laws. So essentially, the main source of authority for local governments to create not just tobacco control laws, but also any laws regarding public health, stems from police power. And although the term may seem like a lay term, everyone knows who the police are, it's actually a term of art in the legal field. So the question is then, what actually is police power? Put simply, police power, the term police comes from the Greek term politeia, which refers to the state, to administration, to government, the functions of government. And in the legal field, it's used to refer to the power of government to enact laws that promote the public health, that promote public safety, and ensure the well-being of the community and the general welfare. So one really well-known example, it would be seatbelt laws. Everyone's familiar with click it or ticket. This is something that is a great example of police power of the government to say, well, you have to wear a seatbelt if you're going to drive your car, and there's going to be a penalty if you don't. This is a great example of a law that's specifically designed to promote the public safety. Another example would be a motorcycle helmet law. Laws requiring you to wear a helmet on a motorcycle, or for that matter, minimum age requirements to drive one. And it's important to note here that the California Constitution, Article 11, Section 7, actually specifically provides for the power of state of city and county governments to make and enforce laws that promote the public welfare. So I'll just read it to you here. It says that a county or city may make and enforce within its limits all local, police, sanitary, and other ordinances and regulations not in conflict with general laws. Now the reason I read it to you is because that last section about not in conflict with general laws refers to something that's important to keep in mind, is that there are times that the police power is actually, there's an exception, where the state government or the federal government in some cases has created a law that says that local governments cannot do something, and this is referred to as preemption. The other side of the coin of preemption is what we refer to as express legal authority. And when lawyers talk about something being express, they're not talking about the bullet train. What we're really talking about is that something is written down explicitly, expressly in a law somewhere. So in tobacco control and in public health in general, this is usually in the form of some phrase that says that a particular type of law is not preempted at the local level. So here's an example. Take a look at this. This is from the California Smoke-Free Entryway Law. So you'll notice from the bold part that it specifically says this section shall not preempt the authority of any city or county to adopt and enforce smoking control ordinances that are more restrictive than the state law. So this is an example of express authority. This is essentially something that you have that says, despite what anyone else may say, yes, local governments do have the authority to do this. So let's give some examples of the uses of police power to specifically advance public health goals. Something that people may not necessarily think about as part of the police power is investigating infectious disease outbreaks, requiring menu labeling in restaurants, creating smoke-free places, as we're going to be talking about more later on, and imposing restrictions on tobacco sales, for example, requiring a license in order to sell tobacco. So back to our roadmap. Now that we've talked about the distinction between a voluntary policy and an ordinance, as well as the source of legal authority for local governments to create tobacco control laws, I'm going to turn it back over to my colleague Ian, and he's going to discuss the anatomy of an ordinance.
Great, thanks, Matthew. Those first two topic areas, deciding on whether to use an organizational policy or an ordinance and the legal authority for a law are really sort of the threshold issues that you must consider when you're deciding, is this an area that we want to address through policy? But now I'd like to get a little bit more specific and get more into the actual lawmaking process, and I'd like to start with the anatomy of an ordinance. What are some of the elements that go into creating a local ordinance or a local law? And in this case, anatomy is actually really an accurate term. The human body operates through a complex series of interdependent systems, each of which serves its own independent function, but is vital to the overall workings of the human body, whether it's your nervous system, your muscular system, or so on. Similarly, an ordinance is made up of numerous interdependent sections, each of which serves its own critical function as well. And I'm going to talk about each of them a little bit more specifically. They're listed here, and I'm going to talk about each of these elements of the ordinance. And these are listed in the order that you would actually find them in most ordinances, and actually this is the order that they're located in most of TALC's model ordinances. But this is not necessarily the order of importance. Each of these is equally important in its own way, as I'll talk about. And the first element I'd like to talk about are the findings, or the legislative findings. The legislative findings really set forth why the legislative body is adopting a policy or a law on the subject. They really define the problem to be addressed. The legislative findings are usually not codified. So that is, if you go to look up a state law in the Health and Safety Code, or you go to look up one of your local laws in your municipal code, you're not likely to find the legislative findings. They're part of the ordinance that will be considered by the City Council or the Board of Supervisors, but they're usually not codified into law. That's somewhat significant, but it's still important to have them, as I'll talk about in a moment. TALC's model ordinances contain extensive legislative findings that are based on the data and the research. And those are legislative findings that you can cull through and decide which are appropriate for your own jurisdiction as you're looking at laws. And also, it's important to tailor those findings to the exact conditions that exist within your city or county. Here's an example of what a legislative finding might look like. This is a finding that summarizes the data and evidence that nearly 4,000 children under 18 years of age smoke their first cigarette daily. And this is the kind of finding that would support a law limiting youth access, like a tobacco retailer licensing law, for example. This is one of the findings that's in our model ordinance. Now, I said that TALC's model ordinances include extensive findings, but that they're usually not codified. So why is it important to have these findings? Well, a couple of reasons. The first is that the findings tend to provide education to lawmakers and the public and others who are looking at the ordinance. Most lawmakers cannot be an expert on every subject, and in fact, they have to consider ordinances and laws and resolutions on a variety of topics that they might not know a lot about. So having the findings in the ordinance itself really provides an educational effect, especially if the findings are supported by the data and the research. Also, they create a legislative record of the reasons for the law in the first place. Even though they're not codified, if somebody's going back to do research on the legislative history of the law, in the original ordinance, they will find the legislative findings, and they can see the reasons why the legislative body decided to pass the ordinance in the first place. If a law is challenged in court, if a party claims that part of the law or the entire law is illegal for whatever reason, the legislative findings can be very beneficial. First of all, if a court's looking at a law and a challenge to a law, they will look at the legislative findings and give them great deference. If the legislature expresses its intent through findings, or the legislative body expresses its intent through the findings, that will get a great amount of deference in a court of law. A great example of this is the recent lawsuit challenging the San Francisco pharmacy ban. A few years back, the city and county of San Francisco prohibited sales of tobacco in pharmacies, and not surprisingly, that law was challenged on a few different grounds. And one of the grounds was that the law violated equal protection, and so Walgreens argued, why us and why not other types of businesses? Well, ultimately, the court that was considering that challenge ruled in favor of the city and county of San Francisco, and they actually specifically relied on the findings in the ordinance to say, actually, based on these findings and what the Board of Supervisors declared in these findings, we think that there is a basis for this law, and they upheld the law very much on that ground. So the findings, even though they're not codified, can be very important. The next section I'd like to talk about of an ordinance is the definitions. This is usually one of the first sections, and although it's not terribly exciting to a lot of folks, it's really important in order to make the entire ordinance very clear. I used the metaphor earlier that there's a lot of interdependent sections of the ordinance, and this is one of the sections that's actually used throughout the entire ordinance. In your typical ordinance, no matter what the subject matter, the same terms are likely to be used over and over again. And so you want to make sure that there is a consistent meaning to those terms so that whenever it's used in the same way. So in addition to just defining the term, in all of our model ordinances and in many ordinances that are actually adopted throughout the state, the defined terms are capitalized throughout the entire ordinance, so that if you're on page 10 and you see the term tobacco retailer and it's capitalized, you know that you can go back to the definitions and find out exactly what that means. In addition to just creating consistency, the definitions actually also help you do just that, define terms that are not easily defined. A good example of that is the term dining area, which we all think I think we all have a pretty good idea colloquially about what we think a dining area is. But if you have a policy that applies to a dining area, you'd like to be very specific about what you mean. And so here's the definition that we use in our model ordinance on this subject, and we try and be as specific as we can so that we can apply the law clearly. So the definitions are important, and the next three sections I'd like to talk about are all sort of interrelated, and they're what we call the operative clauses. They're the operative clauses because they talk about who's required to do what or who's prohibited from doing what by this law. So they fall into three categories primarily: prohibitions, requirements, and then duties and responsibilities, which are closely related to requirements. Essentially, whether you're talking about a prohibition or a requirement or a duty, they all have the same basic requirements of drafting, and that is you want to be clear. You want to clearly state what is prohibited or what is required so that persons who are subject to the law know exactly what it is that they have to do or not do in order to be in compliance. So for a prohibition, you'd want to be very clear, for example, that smoking is prohibited, and where is it prohibited? In these following places within the city that you see on your screen. You also note that most of the places where smoking is prohibited by this clause are capitalized, and therefore you can tell that they are defined terms in another part of the ordinance. Requirements are also similar to prohibitions, except that instead of saying you cannot do something, this says that you must do something by this law. Basically, it's important here to be equally clear as well. So here's another example of a requirement, and this is a requirement that landlords include smoke-free lease terms in their rental agreements. Requirements sometimes require actually a little bit more thinking on the front end to make sure that implementation is practical. If you have a prohibition that says you cannot do something, that's a little bit more straightforward in terms of the drafting and some of the considerations about whether people can comply. But a requirement sometimes is a little trickier if you require something that might not be feasible or practical. So you really want to make sure that you don't look at a requirement in a vacuum, but that you look at it in the whole scheme of the other laws that are in effect and the other regulations that are in effect to make sure that they're practical. And finally, related to requirements are duties and responsibilities. These are very similar. And here's an example that retailers be informed about all laws applicable to retailing. It basically sets forth the duties of persons who are subject to the law, and it's very similar to a requirement. They're just slightly different in that it's an affirmative duty. The next element I'd like to talk about an ordinance is penalties and enforcement. And this is listed almost last in this section, and it's included near the end of all of our model ordinances. But actually, I think that this is probably the most important element, in my own opinion, to think about on the front end. And I would add to this implementation as well, which is a close relative to enforcement. It's really important to consider this on the front end because if you have clear language that says somebody must do something or somebody cannot do something, the next question is, what happens if they do the prohibited act, or what happens if they fail to do what's required of them? What then? And this is where the penalties and enforcement come in. Without that, an effective enforcement section and an effective implementation, an ordinance is still really just words on a page. You can have all of the other elements in there, and you can be as clear as you want, but unless you have some enforcement and implementation, it's likely nothing's going to happen. So it's important to think about who's going to be involved in enforcement, what will happen if the law is not followed, how will enforcement occur, what kind of process will it be, who will be responsible, those kinds of things. And not just think about it on the front end, but also to involve the other agencies that are going to be needed in order to enforce the law. Here's an example of an enforcement clause from one of our model ordinances, and this is relatively straightforward. It basically says that if you violate the ordinance, then you're subject to a civil action brought by the city council with a fine, county council, pardon me, with a fine. And there's a couple of different elements wrapped up into this phrase. One is that the entity that's charged with enforcement is the county council. The method of enforcement will be a civil action, which means a civil lawsuit in court, and the penalty is a fine. So this is good. There's a lot of different ways to enforce your ordinances, and this is one. All of our model ordinances include a variety of different enforcement and implementation mechanisms. Usually an administrative process is very efficient, or sometimes a criminal process is the way to go. But regardless, it's really important to think about these issues up front as much as possible. And then finally, the last element I want to talk about in the anatomy of an ordinance is the severability clause. And here we have the axe versus the scalpel. What does that mean? Well, first let's look at a severability clause. This is included in all of our ordinances, and it's included at the very end, and basically it's a savings clause. It says basically that the City Council or the Board of Supervisors intends that if part of the ordinance is struck down as being illegal for whatever reason or not enforceable, they did not intend to throw away the whole ordinance. Instead, they would like that one unenforceable or illegal or invalid portion to be severed out of the rest of the ordinance, and for the rest of the ordinance, which is legal, to remain enforceable. So going back to the axe versus the scalpel, rather than axing away the entire ordinance because one little piece is unenforceable or invalid, instead the City Council or the Board intended to just sever out that one part. This is very mundane in some ways because it's included in every ordinance as a matter of right that I've ever seen working in city government. But when you need it, you really need it, because without the severability clause, it's not clear whether or not the legislative body actually intended for the remainder of the ordinance to live if part of it is struck down. So that's a quick overview of all of the elements of an ordinance. And so when you start thinking about putting an ordinance together, you want to draft your policy. Let's move to the next section of our agenda, and that is the process for actually adopting an ordinance. Knowing the actual process for adopting an ordinance at the local level, the city or the county, really helps determine what kind of input you can have throughout the process. What are the points of intervention where you can intervene and make public health concerns known, and where can you exert any influence? Along with the key players, which is the next section, I think that the process should be integrated into your campaign strategy so that you can really be effective in your policy work. So on the staircase of the process, the legal process, whenever I'm talking to a community, the first thing that I like to ask is actually, what is the problem to be addressed? A lot of people come to us, and a lot of people used to come to me when I was practicing with an idea that they want to pursue X policy or Y policy. We already know what we want to do. But I always like to back up a step and say, can you clearly define what the problem is that you actually want to address? Sometimes, like I said, the legislative findings can really say what that problem is very clearly, but the legislative findings are really data-driven and research-driven in a lot of ways, and it really helps to have your ideas synthesized. Well, in our community, what is the problem? What are the local statistics? And just viscerally, what's happening in the community that we think is a problem that we need to be addressed? Once you have an idea about what that is, then the next step would be, what kind of policy can address this problem? And then finally, the policy-making process is actually just the process to move that policy idea forward. From an idea to transform it into an actual law. So there's a couple of steps that I want to highlight in the process. And one, again, is the threshold step, and that is to locate any existing laws that impact your area or the problem that you want to address. Whatever the problem is, there might be an existing law that is enforced or is not enforced that already addresses a subject, and it's important to know what those laws are. It might be a state or federal law, or it might be a city or county law on the subject. So a little research is in order initially to learn what's on the books. For state or federal laws, I would refer you to Talc's Tobacco Laws Affecting California book. It's on our website, and it provides a summary of all the state and federal tobacco control laws that affect California, so that it has a really good overview of everything. So very quickly you can determine whether there's any law that might affect the area that you want to go into. But in addition, it's important to research city and county laws, because most California cities and counties have some tobacco control laws on the books. Some of them are relatively recent, but a lot of them might be decades old. And instead of just enacting something brand new, you'd want to either repeal the old law first or amend the old law to do what it is you want to do. So you really do want to find your local laws. How to do that is also relatively straightforward. Most of your local laws are contained in the municipal code, which is usually readily findable on the city's website in most cases. Here's a couple of examples. This is the web page from the City of Calabasas, and you see that I've highlighted the Government tab on the top. And right underneath is a link to the Calabasas Municipal Code. Those are usually kept up to date, and if you clicked on that link, this is what you would find. On the left is a table of contents for the entire code, and then you can locate there Chapter 8.12, their secondhand smoke controls. By reading that, you would be able to identify, do I want to amend that? Does that need to be repealed? Or actually, is that just sufficient already? Does it just need to be enforced a little bit better? Here's a second example from the City of Inglewood. The municipal code here is actually located under the Department's City Attorney's Office tab, and there you go, still not very difficult. And another place it might be is under Departments, the City Clerk's Office tab. This is from the City of Burbank. And regardless of where it's located, it's generally not too hard to find. And actually, most of the city's websites have a search function where you can search for municipal codes. So once you have that knowledge in hand, and you know whether or not you have to amend something or what the landscape is already for existing laws, I think it's really time to put pen to paper and start drafting an ordinance and start creating the policy that you want to create. It's really a matter of just putting the legal language down on paper that meets your policy goals and includes most probably of the provisions that I highlighted under the anatomy of an ordinance. Under California law, a city attorney has the duty to approve all ordinances to go before the city council, and likewise for the county level and the board of supervisors with the county council. How does the city attorney or the county council receive direction to draft an ordinance? Well, first of all, they don't always draft the ordinance, but sometimes they do. Sometimes the legislative body in open session might direct the attorney to draft something. In that case, it's happened in an open meeting for all to hear. Other times, it's very common for another agency head or another government staffer to actually go to the city attorney or county council with either a draft ordinance or a request to draft something. In either case, the city attorney would approve it at the end, but the city attorney would not necessarily draft it from the get-go. So there's a lot of different ways to get an ordinance drafted. Any department head or any government staffer essentially could bring up an ordinance and bring it to the city attorney or county council, or bring it up to the council for discussion. It's just that last step of approving the final ordinance that must be approved by the actual attorneys. Along with the ordinance usually is an accompanying staff report. The staff report is just that, it's a report. It's not required by law, but it's almost always accompanies an ordinance, and it explains what's going on in the ordinance and why the city council is taking their action. It will be part of the legislative record, even though it won't be codified. It'll supplement the legislative findings and really explain what it is the city council or the board of supervisors wants to do with that ordinance. Once you have the ordinance drafted, it will go before the legislative body. And here it's important to really know the makeup of your legislative body. That is, how many members, whether they represent districts, that sort of thing. Usually, whether you're talking about a city council or a board of supervisors, there's 5, 7, or 9 members, including the mayor or the president of the board of supervisors. It's usually a good idea to have an odd number of members. Sometimes they will represent districts if there's a large city or county and they need to divide it into different demographic districts. Other times each of the members will represent the entire locale. And each member will be elected and each will have an equal vote on the legislation. Whether you're talking to city council or board of supervisors, they each have authority over their jurisdiction. So a city council has authority over the incorporated city, and a board of supervisors generally has authority over the unincorporated areas of the county. And finally, there needs to be a quorum of whatever number there is on the council or board to take action. A quorum is usually a majority plus 1 of the council. So before a meeting can even be called or take place, you have to have enough members present. On a 5-member board, that's usually 3, 7, it's 4, and so on. Once you have a quorum and you have a meeting and you have an ordinance ready to go, usually there's 2 steps. First, it will be introduced, and second, it will be adopted. And there will be a vote at each stage. There has to be a majority vote to approve both the introduction and the adoption, and they have to be at least 5 days apart. Generally speaking, this actually happens not 5 days apart, but in 2 regularly scheduled meetings. Most legislative bodies have regularly scheduled meetings, probably twice a month, in some cases a little bit more, but generally twice a month, and the ordinance would be introduced at one meeting and then subsequently approved at the second meeting. How do you know what's on the agenda? Well, you will know that at least 72 hours in advance, because California law requires that the agenda for any public meeting be posted at least 72 hours before the meeting. Now, this doesn't necessarily mean that the ordinance has to be made available, but generally it does. And if the ordinance is not available when the agenda is posted, the public's entitled to receive the ordinance as soon as it's made available to the members of the legislative body. But at least 72 hours in advance, you will know what should be on the agenda. This last bullet point I want to highlight just briefly, and that is after the first reading of the ordinance where it's voted on and introduced, it cannot really be altered in any way except to correct typos. So it's important to have that first draft as tight as possible because it's going to be difficult to amend after it's introduced without actually reintroducing it. You can't just make significant changes and then pass it on second reading. What kinds of opportunities are there for public input during all this process? Well, there's a few different really good opportunities. One is that anybody is entitled to meet with elected officials and government staff at any time as a member of the public. So you can call up your elected officials, you can meet with them, you can meet with other health department staff or government staff and make your positions known at any time. The only prohibition there is for actually a quorum of the board or the city council to meet. So you can't call up 3 councilmen or council members at one time and ask to meet with all 3. But you can call up 1, and you might be able to meet with even 2 at one time and make your positions known. Also, during the meetings themselves, there's always an opportunity for public comment on any item, whether it's on the agenda or not. Sometimes this is limited to 3 minutes during the public comment section, but this is available during all public meetings. And then also on every item that's actually on the agenda, there's a separate opportunity for public comment as well. So there's several opportunities to provide input before the City Council or the Board of Supervisors. After an ordinance is adopted, it has to be certified by the mayor or the president usually. That certifies that it was duly adopted, and then it's nearly law. It's published by the clerk and then becomes effective generally about 1 month after it was adopted. Sometimes there's a shorter period of time where an ordinance might become effective immediately if there's an emergency. Those are called urgency ordinances. And sometimes it's a good idea to actually build in a longer lead time and make the ordinance effective even longer after the adoption date, maybe 3 months, in order to give people time to comply. So with that, that's a lot of information that's largely theoretical and legal that I just imparted. And now I'd like to actually bring in an expert from the field to talk about the practical experience about how the legal process works and where you can intervene in the process. So with that, I'd like to welcome Christine Glaze, who's the outreach coordinator for the Search to Involve Filipino Americans. They do a lot of work in Los Angeles County, and Christine has been involved in a number of successful tobacco control efforts. So welcome, Christine, to the webinar.
Hello, everyone. Hi, Ian.
Hi, Christine. Thanks for joining us today. I was wondering if you could tell us a little bit about your organization first.
Oh, well, Searching Involved Filipino Americans is a nonprofit organization based in Los Angeles, and we offer free health and human services, economic development opportunities to our clients. Mostly, they're from the Filipino American community, but we go beyond that circle. We also have clients from the Latino population and also Asians, African Americans. And we offer after-school services, counseling, small business assistance, housing, etc. But in terms of tobacco prevention and control projects, we've been doing this since 2006, and we've been to Baldwin Park, West Covina, El Monte, and currently in Pico Rivera, and also we helped with the campaign in Los Angeles.
Great, thanks. Actually, I wanted to talk to you about your campaign in the city of El Monte. I know that you recently worked there on a tobacco retailer licensing ordinance. At what point of the process did you get involved in El Monte, and how did you first get involved?
Well, for a campaign such as tobacco retail licensing policy, it is really imperative to have the community prepared. So that's like the first in our agenda. We made sure that we prepare the community and our data first and foremost. So we gathered our public opinion surveys, and we had the results for our youth purchase survey. So just so we have something to present to the council members. So we made sure that we had also enough support first before meeting with any council member for that matter, before meeting our champions. So we made sure that at least we have 5 sure members, committed members from our local coalition before we went ahead and meet with our champion first and with the rest of the council members. It's really important. It pays to meet with each council member just because, you know, during the first reading or the introduction of the ordinance, even with the public hearing, it just helps for them to have been notified or informed about the issue that's going on in the community, and they're not like, you know, caught off guard with the decisions that have to be made by them. So yeah, it really pays to have a solid community-based support and have them present in the council meetings where the issue or where the ordinance is being considered. Yeah.
Well, that's really interesting. Did you, when you met with the council members, did you help prepare a draft ordinance that you brought to them, or how did that come about?
Eventually, the city attorney was tasked to draft the ordinance, and yes, we worked with him and with his team by providing them with model ordinance. We really made use of that, and I would say that they used like 80% of what was provided in the model ordinance, and we also gave them the solid plug-in list and also other American Lung Association data that have been really helpful in establishing the benefits of TRL, especially, you know, like in the section where you mentioned a while ago where there are a lot of were asked clauses. So that has been very helpful to establish really the advantages of having TRL in the community.
Great. Well, so when the ordinance was actually got to the city council for an open meeting, when they were considering the ordinance, did you attend? And if so, what was your role at those meetings?
Yes, we did attend every single council meeting where we are on the agenda or where TRL was in the agenda. So we attended with our coalition members. During the public hearing, we mobilized all our youth volunteers, concerned parents, and community partners for the public comment. So there were around 10 of them who addressed the council members, and they're all coming from the youth, voters, seniors, health, and local nonprofit sectors. And during the first reading, we again mobilized the group wearing our shirts. We have our signature shirts, so even if we did not speak in front during the public comments, at least they could see our presence. We're just like a sea of black and white during that night. And we did a presentation actually with my partner, Ivy Dulai, and we did a presentation to the council. And during the second reading, there was really no need for us to speak or do public comments. We just sat there and, you know, just for the council members for them to see that we are present and really much engaged and interested in what is being discussed about PRL. So we brought, with us fewer members, but the council on that fateful night of November 20th, 2011, they adopted unanimously CRL without any questions, without any objections, which everything happened so fast. We're all shocked. Our coalition members were like surprised, like what did just happen? And we just told them like, they just passed CRL, so everybody was happy, and all the efforts have paid off, basically. All the the coordination with the city attorney, it has a lot of going back and forth, meeting in person, and emailing back and forth, and talking on the phone, and talking with Ian, of course. You've been really helpful with this campaign.
Well, congratulations on that success. It's really interesting to hear you talk about the influence and impact you can have without even speaking during the meetings. I can visualize the sea of black and white that you mentioned in the background.
Yeah. Mm-hmm.
Well, the last question I have is a couple of parts. As a community-based organization, overall, did you feel like you had an opportunity to provide meaningful input into the legislative process? And could you describe what you found challenging about the process and some lessons learned?
Yeah, so yes, definitely. We as a CBO played an important role, but it's not really our nonprofit, but it's through our local coalition. It's through the residents. The clamor is coming from the constituents themselves. So that provided more power and more force for our campaign. And what we did find actually most challenging is actually the actual scheduling meetings with council members. They're busy people, and it's just been hard to plot a schedule and sit down with them and talk to them about the issues and the policy option that we're thinking about. So it's true for both initial and follow-up meetings. So it has been difficult, logistically speaking. And also to mobilize all the members. We made sure that in every meeting we have at least one resident present. So it's not just, we are outsiders. So we just wanted to have our members and the residents own up to the issue, and for them to, express themselves to the council members. So yeah, that's how we went through the process.
Well, that's wonderful, Christine. Thanks a lot for sharing your experience with those on the webinar today and for joining us. I really appreciate it.
All right. You're welcome. It's been our pleasure.
Okay, now why don't we turn it over to the key players in the process with Matthew.
Thanks, Ian. That was really interesting. So Ian touched on a lot of the components of the ordinance, of an ordinance, and the various steps in the process. I'm going to be talking about the key players involved in that process and what their various roles are. So there are a lot of different interests at play when a law is being considered by a local government, and so it's important when working on these issues to understand who's involved and what their roles actually are. So the first set of players are the legislative. They are the ones who are responsible for actually considering a law, for actually getting together and passing a law. They're the city council or the county board of supervisors that are elected officials whose job it is to pass laws. The next are the executive players, and those are often the mayor, the city manager, sometimes the county executive. They're the ones who are often responsible for certifying an ordinance once it's been passed, as Ian mentioned earlier. Next, there's the city attorney or the county council. Under law, they are the ones responsible for signing off on an ordinance, and they're also the ones who are tasked with drafting an ordinance when a legislative body decides that it would like to consider a particular law. Often the first step for them is to direct the city attorney or the county council to go off and draft something for them to actually look at and respond to. Next are the department heads. Oftentimes it's very important to have buy-in from the department heads because they're the ones who are going to have the expertise in knowing what the problem is and how it can be best addressed. So, for example, a local Department of Public Health or a local Department of Environmental Health, sometimes the police department, etc. And in many cases, these are also very important because they're the ones who are going to be responsible for enforcing a law in many cases. Next, you have the city clerk, who, as you learned earlier, is responsible for recording the law. And then one thing that's often overlooked is the importance of stakeholder groups. So community coalitions, local businesses, chambers of commerce. These are all groups of local residents and businesses who do have a stake in the outcome of policies, and so they do participate to a larger degree than many people realize. And so to talk about the real-world implications of all of this theoretical information that we've been throwing out, we have a guest with us, Denise Dennis. Denise has been the director of the Tobacco Prevention Project at Contra Costa Health Services since 1998. Since then, she and her staff have worked with the Contra Costa Tobacco Prevention Coalition to successfully advocate for the adoption of over 30 legislated tobacco prevention policies at the local level, so city and county. In addition to staffing a community coalition, she and other project staff provide technical assistance and consultation to the County Board of Supervisors and to city staff within the cities in the county on policy options and implementation of those policies to reduce secondhand smoke exposure and to decrease tobacco sales to minors. So, Denise, thank you for joining us. We really appreciate it.
Hi, Matthew. It's my pleasure.
So to start off, I'd like to ask you, you've worked with city and county elected officials on a large number of tobacco control policy issues that have resulted in legislative policy. In your experience, what do you think the most important thing is to know about, or what do you think the importance of having a champion is in the jurisdiction that you're working in?
Good question. So city council members who are willing to champion legislated tobacco prevention policy really play a critical role in the policy adoption process. As both you and Ian discussed, they have the authority to bring issues to the full city council and to direct city staff to develop ordinances to address these issues. Mm-hmm. In 2006, a member of our County Board of Supervisors directed us as staff to develop policy options for comprehensive secondhand smoke protections. This actually resulted in a model ordinance for the unincorporated county. A few years later, we had 4 cities that went on to adopt similar laws. In each of those cities, there was at least one champion on the city council that spearheaded those efforts. 2, champions are instrumental in navigating the city's internal policy adoption process, which can vary from city to city. And thirdly, as each city's political landscape is unique, champions can help identify both other advocates and potential barriers to adoption. This information is really crucial in overall strategy development. For example, several policy champions in the past have indicated that there would be concerns about implementation costs. And we as county staff were able to successfully discuss actual implementation costs at the county level and in other jurisdictions for similar laws and provide very useful information to this concern, to address that concern.
Great. And what would you say in your experience some of the keys are to actually locating a champion for some of these policies for those who are working on them?
Interesting, in our case, sometimes the champions have found us, and I think it's really important for folks to know that city council members or staff can actually have a lot of information about you as a resource if they hear about you from a regular email newsletter or through newspaper coverage. So getting yourself out there in the media and making sure that city councils know that you're out there as a potential resource is really important. Our Tobacco Prevention Coalition has identified champions in a couple of other ways. The coalition conducts a candidates and elected official survey every 2 years. The survey provides information about specific tobacco control policy and asks the respondents to indicate their level of support for legislative policy. We have identified potential champions through that survey. And another way that we have been able to identify potential champions is to really keep our ear to the ground through reading local news articles, blogs, and city websites. Coalition members then meet with the city council member that it looks like could be a potential champion, and they'll directly ask them if they are supportive, if they would be willing to champion a legislative policy for their city. Those meetings actually may yield information about other supportive city council members as well.
And so, in your experience, what do you think are some of the most important things to know about how to work effectively with city staff? We've talked a little bit about champions, and city staff are another group of players who I think feature pretty prominently in the process.
Yes, they do. And as you know, each city has its own unique culture and process for developing and crafting local laws. We have, I think, done a fairly good job of using a collaborative approach when working with city staff, in that we spend some time assessing their particular needs and concerns and tailor assistance based on that need. In Contra Costa, the Board of Supervisors has adopted several tobacco control laws over the past 8 years that we've been able to use as models for our cities. Because of that experience that we've had in implementing these laws, we can offer technical support that is based on our own experience in developing, implementing, and enforcing these laws. Generally, city staff welcome information from other jurisdictions on their lessons learned in those experiences. In our case, this may include sharing of our own staff reports and implementation and enforcement protocols. I think it's also important in California we have TALC as a resource to refer city staff to, so that city staff can benefit from TALC's legal expertise in developing model ordinance language and in review of the city's draft ordinances. I think TALC is especially a real asset to cities now in this very challenging fiscal environment.
Great, thank you. And what would you say about working with city attorneys and sort of some of the keys to working with them effectively?
Well, I think that is where TALC really does come in, because some attorneys would prefer to be talking to other attorneys about model ordinances. So there's a role for both local staff and for referring city attorneys to TALC if they would prefer to talk to another attorney. Again, each city's office is going to look different. So some city attorneys may be very welcoming of having community members in public health departments working with their staff, and other city attorneys may prefer to be working with another staff attorney on those model ordinances.
Great. And finally, one of the things that seems to be often overlooked is the importance of community coalitions in discussions of policy adoption. In your experience, what kind of an impact do community groups have on the local process?
Well, our coalition members have been incredibly valuable in a number of ways. First, they have contributed to identifying and meeting with potential champions at the local level. Secondly, they've been instrumental in demonstrating community support and advocating for tobacco control at the local level by meeting individually with city council members, testifying at city council meetings, and writing letters of support. We have found that even supportive city council members, they've indicated the need for members of the community to publicly speak on the importance of tobacco control policy. Coalition members can bring personal stories that illustrate the problem that in a way that policymakers can't. without these advocates, there's a real increased risk of policy being weakened or potentially defeated, because we know that there will be opponent voices, and we want to make sure that the opponent voices will not be louder than the advocate voices. Thusly, we've really found that an active and well-informed community coalition is key to successful adoption of policy at the local level, and also in creating political will for those policy changes.
That's great. Thank you so much. So we're going to move on now to a discussion of the products and services that TALC has available for policymakers, for those who are working on tobacco control policy as they move forward. Denise, thank you so much for your time. I really appreciate it.
Thank you.
So back to our overview. Sorry, it was the wrong slide. We've gone through a lot today. We've gone through talking about the distinction between a voluntary policy versus an ordinance. We've talked about the source of legal authority for local governments to enact tobacco control laws. We've talked about the components or the anatomy of an ordinance, the process involved in adopting an ordinance, and we just finished up talking about who the key players are in the process and how their role really fits together. Finally, to close out, we're going to talk about TALC's materials and the services that we have available to those who are working on tobacco control. So you may be wondering, there's been a lot of discussion over the last hour about, who TALC is and what we do, but you may be wondering, what can TALC do for me? And so this is really our opportunity to provide that information. We do provide a wide variety of technical assistance to those working on tobacco control throughout the state. We can do a variety of things. We could create model language that can be used as the basis for ordinances that you're working on. We're able to review draft ordinances that you may already be in the middle of. We can explain the different enforcement options. I think Ian was correct in saying that enforcement is really one of the most important components of any given ordinance, and so it's really important to understand how those different options compare to one another. We can research legal issues that arise as the process plays itself out, and we can explain legal issues in non-technical language, in English rather than in legalese. So you may be wondering how this process works. How does one actually get help from TALC? It's actually pretty simple. We try to be very user-friendly. The first thing to do is really determine what the policy goals are in your city or county. Once you've had a chance to do that, then by all means contact TALC. You can give us a call or email us. It takes about 2 to 4 weeks in general for us to customize an ordinance for a specific city or county, and this model language can be revised as the campaign moves forward. As the process moves itself along, continue to call TALC with any questions that arise along the way. And really what we sort of say as a catchphrase is that for best results, contact us early and often. So in closing, as we are lawyers, we actually do have some disclaimers that are important for us to get out. So the first is this one. And then our second disclaimer is here. All right, and then just lastly, I wanted to give a sense of the types of documents that you might find if you take a look at our website. In addition to our model ordinances, we have these very handy checklists that break down in in pretty easily digestible format what's contained in the different model ordinances. So for example, here is the checklist for our model tobacco retailer licensing ordinance. And you'll notice at the top, or on the top half, it has the basic components that are very standard that go into most of these ordinances. But then on the bottom half, we have what are called plug-in policy provisions. And these are really the different policy options that are available that cities or counties can choose to include in their ordinances if it meets the needs of their community. We have model ordinances for smoke-free outdoor areas, so places like outdoor dining facilities, service areas, parks, etc. Again, we have the same checklist available for those. And then smoke-free housing. We do have a model smoke-free housing ordinance with our checklist. And we also do have a wide variety of fact sheets that we think are very useful, that really break down what these various different models do in a way that's accessible and that isn't overrun with jargon and legal terminology. And so with that, I'd like to conclude. I want to thank everyone who helped us out participating and encourage those of you in the audience to take a look at our website at www.phlpnet.org.
Thank you. Please stand by.